Yes.
Am I audible?
Yes.
All right.
I am pleased to introduce the panelists, Advocate Sahana Manjesh and Advocate Sandeep Hari. Advocate Sahana Manjesh practices in the trial and appellate courts in Mumbai. She represents children in conflict with the law before the JJB, Children's Court and High Court in association with the Ashiana Foundation. We also have Advocate Sandeep Hari. He has an MA and LLM. He is a fair trial advocate with the access to justice for prisoners at NALSAR University of Law. He has been practicing as an advocate for 5 years. Apart from practice, he has been associated with Spurti Foundation Orphanage since 2008. I now invite Bharti Ali, who will moderate this session. Bharti Ali is a development professional and social activist working on gender and child rights for over 3 decades. Passionate about child protection and access to justice, she has closely worked with several organizations, networks, and government bodies for the realization of children's human rights. I will now hand over to Bharti for moderating this session. And
Yeah. Thanks, Anne, for setting that ground. And as Anne mentioned, this is one question that came up while we were engaging with some lawyers who have become part of the fellowship program that is initiated by Enfold. And one of the questions was, who do you represent as a lawyer? Is it the child? Is it the parent? And what happens when there are conflicting rights? There is a victim who's also a minor and a child who's also a minor. So a lot of questions have been coming up, and we thought that we probably need to understand what representing children in conflict with law actually means. So we have wonderful panelists with us, and I think we'll do 2 or 3 rounds of questions. So my first round, is about what does it mean to you, when you say representing children in conflict with law? What does it personally mean to both of you? So maybe we could start with Sahana and then move on to Sandeep.
Thank you, Bharti, for the question, and thank you everyone for joining. What representing a child means to me is a little different from what it is when I'm representing a client in other situations, because I feel that I get involved not just with the case but also with the child in the process of representing the child. So it includes things like understanding how their time in the observation home is spent, what are they spending it on, how are they coping with the long time it might take for a particular case to reach its conclusion or go to the next stage. And it requires me to be able to explain what is happening in a way that they understand. Because, of course, one is to explain what is happening to the parents. The other could be to explain what is happening to their counselors. But the counselors or people within the observation home, they understand what the process is anyway. So when I say, this today it was listed in the High Court, but the matter didn't reach, I don't have to explain further to someone who understands how a High Court is works. But if it's a child, then I need to explain what it means while also sort of setting expectations. And I think that's something that I've learned over time, not to overpromise, which we don't do it in any case. But I think I'm even more circumspect when I'm sort of saying, okay, these are the options, these are the processes, and these are the possible outcomes, and sort of set that context right so that I'm not giving too much hope or too little hope. That's something that I realize is necessary to do.
Thank you, Sahana. Sandeep, what are your thoughts? Or what do you have to say?
Yes, thank you so much for inviting me. Now, regarding what it means to represent a child in a case. So for me, it's a very sensitive issue. I feel that this is a different niche, and we are dealing with somebody who is having a first time experience with the whole justice system in a different aspect. They are not a CNCP, so when the whole police and the judicial system is with them, I personally feel that a certain level of sensitivity is required in dealing with such children. And for me, so far, till that age, that child has not been exposed to certain powerful institutions. So how every person in the system is dealing with that child will affect the outcome, whether of the actual outcome that we want, that the child should not get back into recidivism, or that the child should quit a particular action. So for me, personally, representing a child is a kind of practice that takes extra effort. We need to go extra mile. We need to be much more sensitive and understanding their situations. And more important than anything is hearing the child, which I feel that so far in that stage, nobody hears a child. And people are interested in putting their own views, their own morality on the child, not understanding what the actual situation of the child was. So I feel that taking it little sensitively is what matters to me.
Thank you. And in fact, you've led me to the next question. When you talk about hearing the child, what is, right to be heard in a process for a child in conflict with law, particularly? Because this is not a group, a lot of lawyers I've known have refrained from actually representing children in conflict with law, particularly when they're involved in some very heinous offenses. So what does that really mean? How do you protect their right to be heard, the principle of best interest of the child in the process? Maybe you could share your personal experiences, some challenges that you have faced. And Sandeep, you could start. I remember while we were on the call, you did share some excellent experiences. Maybe we could hear from you and then move to Sahana.
Thank you. I'll try to share my experiences. So, initially, when I uh, started dealing with children's cases, um, my only interaction used to be with the superintendents of the observation home, the JJB magistrates, and the police of the concerned PS that has apprehended the child. So that is where my conversations used to stop, because I never went to the observation home to actually speak with the child. Now, slowly we got a window to enter the observation home and get to interact more often with the children. Now, when that started happening, it actually changed my perspective, because slowly the children, when they saw my face more regularly and also noticed that the children's cases whom I was dealing with, there was some result, some movement in those cases, because otherwise they would be there for several months and nobody would be bothered. And especially, nobody would be there to act as a bridge between their parents or their guardians and the children. So ultimately, because of the lack of the bridge and counseling with the parents and families, we would go by whatever is being projected to us. So, a couple of examples, if I may share. There's a sensational case of a girl. The allegation was that she murdered her mother. Now, this was extremely sensational all over the news. The child's all details were put across YouTube and other social media. She was made a scapegoat for everything. She was put in the bad light. Now, ultimately, nobody spoke about her being previously in CNCP, in the children's home. So when I started speaking with her slowly, of course, it took a lot of effort to make her open up. Then we came to know that there is a different story to this whole version or narrative that is being run in the media altogether. So she is the child of the her father's first wife, and so this was essentially a family dispute between her and the stepmother, and some narration had gone in. She was driven into the out of her home, sent into the children's home. Now, ultimately, when she was brought back to her home, again some issue happened. Somebody else was involved, but ultimately the family took an advantage because her father had a lot of property on his name. So they put her in. Now, this case, we are yet to face the trial, but of the material that we have seen so far, it is absolutely clear that things are only put fabricated on the paper. But if I had not spoken with her, we would have gone generally with the child, assuming that whatever trial we had to do. Now, there is a similar experience of a child that we had met in an adult prison. When we met that boy in the adult prison as a part of our prison clinic, during our first visit, he was only requesting us to help furnish sureties because he had gotten bail by then. And he never informed us about that he was a minor. But we were a little suspicious based on his appearance, so we just asked his date of birth. So he mentioned a particular year, which in our view was on the borderline. And then he told that he's actually a minor, and he informed the magistrate, but nobody was listening, so he kind of gave up on it. After that, we had to go back to his native, that's almost about 400 kilometers from Hyderabad, and go to his school through some other social workers network there, get his documents, and then file a petition to look for his juvenility. And then we had to shift him to the observation home, get him released. So had we not spoken to that child, we wouldn't have probably seen that outcome that he should be treated under the juvenile justice system. Similarly, there's another example of a boy whose elder brother was involved in some case, apparently, according to this child. And he, his mother, his elder brother said that, look, because you are young, you keep quiet, you say that you are involved in this, you admit it, you go and make a confession. Anyway, you're not going to face any harsh punishment. But we would say that, it is possible that the child would have made up the story. Actually, when we looked at his apprehension report, we were able to connect the dots that what this boy was telling was true, and how he was actually made a CCL in this particular case. So the point I'm trying to make is that the more we slowly at least start listening to the children, they will have a different version. There was a case of one boy who came back. So I got him out on bail. I found him back again in the observation home. And prior to his release, we tried to do some counseling with him. I was sad that this boy came back again. So again, it took us a lot of effort. And he revealed that the issue here was that his father has lost job. He's not in a position to work. His mother is finding it very difficult. And somewhere there was some encouragement to this child, or maybe pressure to this boy that, look, you have to do something. Now, for him, he didn't know what to do. He was too young to take up any job. So the only way he found it was to go after chain snatching incidents. So he got involved, unfortunately, in that. Somewhere he was caught in some CCTV footage, and he's back in the system. So then we had to counsel his parents and all. Now that boy is out, it's been almost 1.5 years. We've not seen him back in observation home. So these are some examples I wanted to share.
Yeah, thank you so much. In fact, you're clearly pointing out the need to listen to the child's point of view, their perspective, their version, and therefore to be speaking to them on a regular basis. And if that requires, visiting them wherever they are, then taking those necessary steps, going to the school, as you mentioned, counseling, so a lawyer also has to sometimes become a counselor. You're clearly pointing out to some of these very critical needs while we talk about representing children. Sahana, I'll come to you. If you could share your experiences, and particularly, in cases where, the child has probably committed the offense, the facts are all suggesting are going in that direction. And also when there is a conflict between a child's interests and parents' interests, because your wakalatnama is probably signed by the parent, not the child. So if you could help us navigate these spaces as well.
Yeah, so I think one of the fundamental things when you say the child must be heard is, of course, for us as lawyers to get our instructions about the case from the child, right? Because originally it's perhaps the parent who's come to you. The parents always think that the child has done nothing wrong. Or sometimes it could be that people in the observation home think of you as a lawyer, they can refer a matter to. They have a certain perception of how the child is behaving within the observation home. All of these will, of course, help you understand what has happened. But the best source of information is, of course, the child. And I think by the time the lawyer is speaking to the child has spoken to so many people about what has happened. It could be because the mental health report has been prepared. It could be that the probation officer has asked him or her It could be that, of course, the investigating officers have asked. So many times they've probably already said a lot of things. And we are asking them as lawyers to repeat what they have said already. But I think one of the things I find important is to say, I don't want to have this conversation in front of anybody else. This is really a private communication between you and me. No matter what you tell me, I am not going to judge. And for that, it might take me more than once to meet the child. I can't expect the child to trust me the first time we meet. So the first time we meet, I try and make sure that I know all the facts in the charge sheet so that the child feels that I've prepared. I've sort of read what is there and am able to explain what is there. And when I can do that, then the child will open up to say, okay, so and so is what happened, and this is what led me to whatever it is that has happened. Now, again, I never ask them to tell me if they've done it or not. That's not something I ask any of my clients. It's unnecessary for me to know. Whether they've done it or not is not a question for lawyers to know, right? It is, however, important for me to know what are the questions I can and cannot ask. Say, for instance, at a cross-examination. Is it something that's going to backfire? That I will ask. That is something that I make sure to ask. But of course, as a lot of you would know, some kids do sort of volunteer a lot of information. And sometimes it's also my job to tell them, say, for instance, if the preliminary assessment hasn't happened, and I'm meeting them before that process to say that they don't have to explain everything that has happened and that their right against self-incrimination remains. There are too many authority figures, right? We are one more authority figure. How do they know we are any different from the rest of them? We need to make them feel that we've got your back, we are on your side. No matter who else may or may not be on your side, we are on your side. And this could even mean sometimes saying, I will not tell your parents about this. You know, if there's an answer that they've given me to a question that I possibly might be asking across, and they're uncomfortable because this might reach the parents, it's for me to tell them this is literally between you and me. It's also not going to go to the counselor, right? Because again, the way it works in Bombay, I think it's very convenient for me as a lawyer. The observation home and the JJ board is in the same complex. So when I go for my matters there, it's very easy for me to meet my clients while they're there. The difficulty is when the case is, say, before a high court or the children's court. Then I may not always get to meet them at the time. So the other thing that I feel is important is for me to go back and communicate what has happened in the hearing so that the child knows. Sometimes I realize I communicate something to the parent has communicated something very different to the child, and the child thinks, Papa ne bola ki mujhe saza hoga. That's not what I would have said. I would have said, ye hua to wo hua. But by the time it reaches the child, there's too much anxiety. So I feel that direct communication is the best thing. So this is to answer one part of hearing the child, right? The child is somebody I need to get my instructions from. But the other thing, and I see Maruk ma'am is here, and this is something I have learned looking at how she presents cases in court. She makes sure that the child is heard because she makes sure the judge understands the entire concept of the GJI. So if it means taking them to the principals from the scratch, and Maruk ma'am has done this painstakingly for many judges over the course of all these years, but it's a masterclass for anyone sitting in that course. But specifically for the judges, for them to realize that, okay, one is, of course, we understand CCLs have to be treated differently. Of course, that much basics understanding is there, but what does it really mean? To take them to the principles of Section 3, I think that's a wonderful way to introduce the JJR, right? It's very much the heart and soul of the JJR. And once the judges realize that this is, in fact, how they're supposed to be looking at the cases, then they may be open to saying, okay, now let me look at the probation officer report. So then there's a little bit of the child's voice that's come before the judge. Otherwise, they don't want it unless you say, why don't you call for this record? Why don't you look at this report? Why don't we try and understand the child's side of things, right? So I feel one is for us to hear the child, and the other is for us to make sure judges also hear the child, both of which are relevant and important.
Yeah, very well said. And that perhaps is the most challenging task, to get the judges to understand the JJ principles. Yeah, Maruk is here. We'll hear Maruk also maybe sometime later when she probably can be requested to come in on some of the questions as well. That's if she agrees. But taking us through these experiences is really made me think about some other things as well, Particularly, as I said earlier, when there do children have access to the documents in their case? Do lawyers get access to documents in children's cases? So how do you work around that? Because that's been a struggle for a lot of lawyers in juvenile justice boards. Would you like to come in, Sahana, and then we can take it from Sandeep?
Sure. Again, I think spoiled in Bombay, we do have access to papers. Once in a while, if there's a new magistrate who's just come into the JJ board, and I say I haven't got a copy of the mental health report, she'll say, no, this has come in a sealed cover. It's only for me, but you can take a look. And then I have to show the rules, or then I have to show judgments to say, no, this is a matter of right, that I have to get every document that is before you, so that I'm able to say, for instance, mount an effective argument at the stage of preliminary assessment. So getting documents has not been that much of a challenge, but explaining those documents, I think, is something that I realized I need to do now, because I myself wouldn't really understand what psychiatric reports meant or said half the time. It took me some time to understand what are these metrics, etc. And to then sort of also make sure that I tell my clients, this is what we've got. This is what has come in the mental health report, the psychologist report, because now we have psychologist reports that are also being done as part of this process post Baran Chandra, whether it's because cases have been sent back for this assessment or in new cases that started. Again, a long way to go, but still. These reports, I think it's important for us to also explain to our clients and also to ask them what was asked of you when you were taken to JJ hospital, when they were doing these tests, what was asked of you, so that I understand if the report is perhaps, is it actually corroborating what I have been told was the questions that my client had. So yeah, just to say, we don't have an issue with the documents, but I feel it's important that we understand the documents better along with our clients.
Sandeep, what do you have to say?
Yes. For us, accessing documents is very difficult, at least in Telangana. The difficulty is the police feel that the parents are not fit enough to be given any documents in the first place. So they will take their signature on the apprehension report which is prepared, but they don't give them any copies. The child anyway has zero understanding of his case. All he knows is that now the police is going to take him somewhere. And the magistrates also do not check whether the parents have been given any copy. Of course, during the time of production, parents are mostly insisted that parents should be present. They are also present, but still, that question is not asked. Their parents also don't know that they need to ask for any copy. So everybody keeps quiet. So ultimately, by the time we enter the situation, it's several weeks since the child is in observation home. We don't get intimation immediately when a child is brought, at least for the kind of cases that we deal. So then we have to go into the section and get a copy of the apprehension report, and then understand what is the case against the child, and then go back to the observation home, speak with that child in general as to what happened in the backdrop of his apprehension, who handled him, what happened, and all. Then we'll get to know some new facts. Accordingly, we draft the petition and then we file the bail petition accordingly. But overall, when we see the difficulty we have is with the magistrates here, they believe the version of the police. But in several cases, what the magistrates tell us is, sir, don't tell me that, because the police don't tell me that the police don't have any work to go after some random child. So there could be something. Is there some recovery? So that's the amount of trust that our magistrates have on the police. And that is the difficulty which actually continues even during the inquiry proceedings also, because the police now are standing outside. So they tell the children that you go and plead guilty, nothing to worry about it. You will be fined some 300 or 500 rupees. That's the end of it. The child comes in, they plead guilty. Now, in this entire process, they don't get that kind of representation or guidance or suggestion. So they go, they plead guilty. They don't realize that the next time the police is going to again pick them up for some other theft case. and then the magistrate is only going to say that he is an habitual offender, he pleaded guilty previously. So this happens actually in our JJBs when we deal with children's cases, and then it's a very difficult process for us to explain the act to the JJ magistrates, because they are given additional in charges. We don't have full-time JJ magistrates. They are all regular judicial first-class magistrates and also junior civil judges. So they are only, no, we have zero, what do we call, JJ magistrates or JJ boards with a full-time magistrate in it. So for them, they don't understand this whole subject itself. It goes in the
Right.
regular manner. So that is the other difficulty we have.
Right. And I think plead guilty is something that really needs to be questioned, because it is directly leading to a whole lot of other violation of a whole lot of other rights, including right to be heard, right to fair trial, right to self-incrimination also, right against self-incrimination. So, yeah, that is a debate in itself. And we'll probably need to have another session around that. But one last question before I open up to other participants. Um, is video conferencing used as a tool, when you insist on hearing the child or interacting with the child, and it's not possible for the child to be present physically? Are these kind of new tools being used in cases of children in conflict with law? Or are lawyers asking for such, using such tools? Sahana, would you like to come in?
So I have not seen video conferencing facilities being used for the CCL to be produced in court. When the trial happens, if they're in custody, they are brought from the observation home, or otherwise they appear on the home. But before the JJ boards, I'm seeing now that a lot of witness testimonies take place through video conferencing, because that facility is something they feel will speed up the trial. Again, I mean, I am on the, I have a few reservations about the use of video conferencing in a trial. I feel that it takes away a lot of rights, especially when it's cross-examination of very important witnesses. So even if it were a facility available, I think I would push for my client to be present in court with me. Because if I need to take immediate instructions, I cannot do it on a video conferencing. It's certainly not going to be a confidential communication. And again, like I said, in Bombay, the children's courts are not so far away from the observation homes that they can't be produced easily. I understand that perhaps the thing that we wait against is the time it takes for the trial. If the production is not happening because they don't have enough escorts, because the court is very far away. That's not the case in the limited practice that I have. So for me, video conferencing, I think, is not necessarily the best way to conduct a trial. Maybe for procedural issues, if it saves time, fine.
Sandeep, your views.
Yes, we also have a difficulty with video conferencing facilities, and our difficulty is that we have very few number of observation homes. We have out of the 33 districts in Telangana, we have 23 with juvenile justice boards, but there are only 5 observation homes in the entire state. So that means there are certain JJBs with observation home about 150 or 200 kilometers away. Now that the child is never produced, so the extension also happens quite mechanically. So in that perspective, at least for the adults, I feel every 14 days there is a phone that is kept before the magistrate and he mechanically will extend. In the child's case, this doesn't happen for us, because the difficulty is the communication in observation home is not that well set up. So it never actually happens for us. Now, even during the inquiry proceedings also, it is surprising that there are some cases where, because of this distance, the magistrate says, look, there's for cases where, other than the preliminary assessment or heinous offences cases, for the petty offences or regular minor offences, the magistrate says that, sir, you see, you are representing, so we don't have any difficulty, you can proceed. So this kind of steps have actually been taken. That is in the absence of the child also. If I may give an example, actually we had uh, a difficulty where the magistrate was in Adilabad district. That's about 300 kilometers from Hyderabad, more than 300. And a 7.5-year-old girl and an 8.5-year-old girl were brought as CCLs. So they are in observation home. Allegation against them is theft. Now, we spoke with the magistrate on video call. We said, look, this is the difficulty of the child. You put this child in an observation home. You could otherwise put these children in children's home. Now, the magistrate did not understand the whole thing as to what was happening. That whether the magistrate can send a CCL into as a CNCP, even though the case is pending, and you send the child as a CNCP to a children's home. This difficulty came, the magistrate is not understanding, those children are crying, so the observation home superintendent had some uneasiness, so she turned the phone to herself and she is communicating with the magistrate. All this was happening, so we told her that we have this request, you please ask these children to be produced before you, or you may take steps to look at the children physically. And ultimately the magistrate got convinced. It took a lot of several days, and then we were able to. So what the order came was that because the for the girls we have only one observation home and one children's home. They are both separated by one floor. The order, very surprisingly, is this: that when the classes are going on, you take these children upstairs into the children's home, and other than that you can put the children back into the observation home and you bring them down into the first floor. This is the kind of order. Of course, we are now challenging that order also, that you don't put children here and there. They'll easily figure out that something is wrong with the kind of treatment that is given vis-a-vis the other children, the girls who are there in the children's home. So this is the difficulty we have with video conferencing in our boards.
Yeah, so very clearly, children's right to be heard, children's right to be represented, keeping their best interest in mind is requiring some very careful thinking and ethical practices. Thank you so much for highlighting your views, and we'll open it to questions. But I'd like to come back to you after, the question and answer round to get your views on what would you suggest as solutions, as possible strategies that lawyers should adopt? You've already highlighted some, but just to bring it all together. So any questions, people can raise their hand or type it in the message box. Anne, will you help me with this?
Yeah, as of now, no one has raised their hand or written in the chat box, but participants, please feel free to raise your hand if you want to ask questions or give any comments.
Okay, since, while we get questions, Maruf, since you are part of this webinar today, would you like to share some of your experiences or anything that's coming to your mind which you feel, would be a learning for all of us? You'll have to unmute yourself.
Well, as a lawyer, as both lawyers have said, as a lawyer, we play an extremely important part in the child's right to participation because very often we are representing the child. So we are enabling the child to participate also. So that's why meeting the child, talking with the child is extremely important. But what my experience shows is that, when you want to get the trust of the child, one thing you really need to focus on is doing. I've noticed their whole way in which they look at you changes when you just tell them, I'm going to ensure you get up on bail, I'm going to go. If we lose in the JJB, we file an appeal, we challenge it because even the parents trust, however much you try to tell tell them how important preliminary assessment is and challenging the order of transfer. They don't look at it with the severity it should be looked at. Their main focus is on bail. So I think someplace, somewhere we have to have our networks ready to know that we are going to go all the way to the High Court if they're not going to get bail in the lower courts. And another thing I feel is, it's also very important for us. Many of us are practicing in other courts too. It's very important for your child to see you are there on every day to see that you are present. And just now Sahana said as to how we read the objectives, read the principles, but it's not only for the judiciary, it's also for yourself. We think we know every word in the principle, think we know every word in the preamble, every provision of the law. I do JJB matters every day, I know it all. But every time we read it. So that is my only thing that, every time before we go to court, please read that provisions of the law. Because every time something jumps up. This is a very and of course, if they're not ready to listen to the convincing judgments of the Supreme Court, they just need to carry it. Sometimes they want to take even the judge doesn't really trust you. They think you're taking them for a ride because how can the law do so? How can the law treat a child who is murdered in such a manner? The law does say that, you say that, we're going to get into trouble. So that's why carrying these precedents and judgments becomes extremely, extremely important, because to know where higher court has also said what you are saying and you're not just pulling things out of the hat. And I'm so happy to see so many lawyers in your fellowship program. Thank you.
Thank you, Maruk. Yeah, we are also happy to see many lawyers now coming up and representing children in conflict with law. So we have two questions. One is from Swagata. She's asking, how do you apply the best interest principle when dealing with a case that involves a child victim? And the other question is from Geeta Sajjan Chetty. She's asking what to do in cases when the family says the child should be inside the observation home and the CiCL wants to get out at any cost. So who is the client? Whom should the advocate listen to? We'll take these two questions and then come to Bushra, who's been raising her hands. Sorry, Bushra, you'll have to wait a while. Let's take these two questions first. Sahana.
I'll take the second question first because I just read it also. I think what we need to understand then is Section 12, right? What does Section 12 do? As a lawyer, I'm supposed to say, and I'm supposed to push to say that bail is a legal, statutory, mandatory right until and unless the child coming out could be in harm if he or she comes out, right? That's Section 12. Now I have to work on Section 12. Again, I need to understand where will this child come out. So the family is saying, no, we don't want the child. It will require me to understand why they don't want the child to come out. Is it because they fear that the victim side is going to come and threaten them? Because this happens. It has happened recently with one of my clients and it really did scare me. But several bail orders already have conditions like the CiCL will not be in touch with the victim or will stay out of the jurisdiction of the police station where she is living. So these are things that we can discuss with the family to understand, okay, not in your house, but where else? Can it be in the uncle's house, in the aunt's house, somewhere else? Because I think we need to understand where the parents' hesitation is coming from and also let them know that, continuous stay in an observation home can make the child get even more frustrated. So if it's because they feel that the child is difficult to handle, it's going to get worse. And like Maruk ma'am is saying, bail is the first thing. It's not about how good or bad the observation home is. It's a restriction of freedom. So I would say the conflict is to be resolved A with Section 12 and B by understanding what is the fear really and to see if there is a way out.
And the next question.
The next question is about balancing the rights of when the victim is also a child. And okay, I don't see how there's a real conflict, to be honest, for me, because I will, of course, be representing the CCL. So I hope that it is the lawyer who is representing the victim who will be taking care of their interests. Again, it could require certain things like me telling my client that they cannot be in touch with this victim. So sometimes it could be a consensual relationship, right? Despite which there's a POXO case. So then I'll have to explain that it could be that it is a consensual relationship if the bail condition requires that you not talk. And also, not even if the bail condition may not require it, it's a general principle, right? You don't intimidate witnesses. This is something we understand while trial is ongoing. So it's important for me to explain to my client that they need to maintain this. And of course, the way to say it is your bail will be cancelled if you do. And I think if I can explain it in those words in a way they understand, then I assume I'm trying to take care of the interests of my client while also protecting the victim.
Sandeep, how would you like to add to what Sahana has said?
Yes. With regard to cases where the parents don't want the child to be brought out on bail, we face those issues a lot. Uh, the difficulty is that I notice that parents magically think that your everybody's children should suddenly become the best in academics. They should always be too obedient, and they're always sitting. You put zero efforts in giving that atmosphere in educating your child, but then you start complaining that ye bahut shaitani karta hai, ye hai, he doesn't listen to us and all that. So now they think that the solution is to get rid of them somehow. So the best solution for them is to put this boy in the observation home, and even magistrates also quite a lot of times they say that let him be there, he'll understand, because they know that the observation home has no difference from a adult prison. I visit regularly adult prison. I also visit observation home. For me, there is zero difference. The only thing is you will find all children of certain groups in this place, and you will find adults there. Other than that, for me, there is nothing different. So putting that child here, I've seen children there for 1.5 years, 2 years. What difference does it make? I mean, their classes, they don't get proper schooling and all like the children in the children's home, because those children are sent out. The concern is these children, if they're sent to the regular school, they run away. So therefore, they have huge walls and all these fencing. So I asked the parents and also the JJB magistrate, so what is it that we'll get? You say that, look, he'll learn a lesson. The parents say they don't want him to come out. But what is it that we'll get by keeping this child here? We'll keep them for 5 years, and then they'll become adults. What do you want to do ultimately? Because we're not giving them any training, we're not teaching them anything. They have no school, they have no music, they have no dance. They have a small ground, they go and play occasionally, that too once in a week or so. So that is a difficulty, of course, we face. We therefore have recently started a program with our social workers, where after the child is released, we are trying to keep in regular touch with the children. We tell the parents that, okay, look, we'll also be there, because the difficulty is there are, at least as per the JJ Act also, a child can be released on bail either under the care of their parents or guardian or fit person or a probation officer. Ideally, if you look at the spirit behind the law, it could have been that because the children have get into this system because of the negligence of their own parents and guardians. Now you want to send them back. So you have a proper system of a probation officer. Ideally, if that system works well, that somebody is there to observe the child and help them, counselor should be there, because there is no other system. So we think that punishing the child by keeping them here will teach them a lesson. So we are trying to build that system where we have some counselors and some social workers to interact with the children subsequent to their release. Now, with regard to the victims, as Sahana had informed, for us also, we have not faced particularly any issues, at least in so far as child victims are concerned. There was one case, so it becomes a little sensitive only when those two cases which I have dealt, which went to the children's court, where the child was to be treated as an adult. That was also in a consensual relationship only. So, but in the other cases that we deal, we don't have the issue. There, of course, we find that the systems are there in place in the children's court for the victims, so they have everything separately. Processes also are like that. Actually, it is adverse to the CCL only, because our children's courts are POXO courts. So these POXO courts are not designed for child as a victim. not child in the accused box. So those even when we have CCLs, they are made to sit in the same place where an adult would sit in the POCSO court if he is accused. So they are waiting outside. You have adult accused there. So that difficulty we have with it's the other way around for me.
Yeah, but this often is a very tough space to navigate if you come across such situations where you have to balance the rights of the victims as well as children in conflict with law. And I'm sure, as we move on with our program and we get more lawyers like you coming on board and taking up these cases, we'll have more knowledge and experience to share on this. Bushra, can we have your question, please?
फर्स्ट
Yes.
मैं मेरा खुद का इंट्रोडक्शन देना चाहूंगी। मेरा नाम बुशरा है। मैं टाटा इंस्टीट्यूट ऑफ सोशल साइंस के स्कूल ऑफ सोशल वर्क जो है उसमें क्रिमिनल एंड जस्टिस डिपार्टमेंट का एक फील्ड एक्शन प्रोजेक्ट है, रिसोर्स सेल फॉर जुवेनाइल जस्टिस, जहाँ पे एज ए सीनियर सोशल वर्कर बोल के काम कर रही हूँ। सो मैं अभी फिलहाल पूना से वर्क कर रही हूँ। तो पूना में एक केस आया है जहाँ पे लड़के ने जब क्राइम किया था तब उसका एज 17 था, बट पुलिस ने जब केस रजिस्टर किया तब उसको ऐसा लगा कि ये लड़का अडल्ट है और उन्होंने उसको अडल्ट कोर्ट में प्रेजेंट किया। ये एक पॉक्सो के केस के बारे में बात चल रही है मेरी। तो जब उन्होंने एज अ अडल्ट बोल के उसको ट्रीट किया, लड़का 9 साल तक जेल में रहा। उसके बाद पॉक्सो कोर्ट ने उसको यहाँ पे जुवेनाइल जस्टिस बोर्ड में पेरेंट्स ने उसका सर्टिफिकेट, बर्थ सर्टिफिकेट दिया, जिसमें उसकी एज जब वो क्राइम कर रहा था तब 17 ईयर थी। तो पॉक्सो कोर्ट ने वो केस ट्रांसफर किया है जुवेनाइल जस्टिस बोर्ड को। आफ्टर द 9 ईयर जुवेनाइल जस्टिस बोर्ड ने बोला है कि उसका प्रिलिमिनरी असेसमेंट करने के लिए अभी ऑर्डर दी गई है। तो 9 साल ऑलरेडी हो चुके हैं, तो ये कितना वैलिड हो सकता है कि उसका प्रिलिमिनरी असेसमेंट करना और उसको ऑब्जर्वेशन होम में रखना। फिलहाल में जो CCL है उसकी उम्र हो गई है 25 ईयर प्लस। तो
Okay.
अभी यस
ठीक। सहाना, संदीप, आप में से कोई रिस्पॉन्ड करना चाहेगा क्विकली, क्योंकि बहुत और क्वेश्चंस हैं हमारे पास चैट बॉक्स में आ रहे हैं और टाइम ऑलरेडी ऑलमोस्ट क्लोजिंग टाइम हो रहा है।
See, obviously at this stage preliminary assessment मतलब होगा भी तो mental health का assessment नहीं हो पाएगा, because the assessment is supposed to be of the state of mind at the time of the offense. So on that on that technical ground, nowadays whenever there have been remands of cases, even if it's a child being tried as an adult in a children's court and then it comes back, the Juvenile Justice Board has to retain the case with them. But in your specific case, I would assume a good idea would be to go to the High Court, seek its inherent powers and say the 9 years have anyway been spent. There is no point in continuing with this process. I think there have been Supreme Court decisions where the issue of juvenility has been raised. Again, you can raise it even after the whole appeal process is over, right? So I would suggest invoking the inherent powers of the High Court so that there is no further infliction of processes on this person.
Thank you. There are some questions related to the discussion we've had earlier. Sagar Mudol says the general practice is we obtain wakalatnama from either of the parents of the child and get the facts as same. But in few situations, we will not take the opinion of child into consideration. If the child does not want to involve their parents, can that be possible? What does it really mean? Representation through the next friend. What would that mean in such a situation? If the child doesn't want to involve the parents.
Sandeep, do you want to answer this?
Yes. So for us, at least what JJBs are permitting us, we've had this difficulty where parents are not interested. So the child says, so they have disputes between themselves, the parents and the child. So we have taken only in one case, you can't take minor friends. into the wakalatnama. So there was a case in which we had taken the child's friend's father was interested to support this child. So we had presented that case. So, but yes, there is a difficulty because our JJBs would say that the parental bond has to be furnished only by the parents. And if the parents are not there, then you can allow a relative to stand. This was one case where we had to go through the whole provision again. And but otherwise, yes, that was only in one case where we have taken somebody else's wakalat for a child.
You want to add to that, Sahana?
So
And
what
also,
I
how did you
say,
navigate? How do you navigate that? Because yes, I can see the boards being very, very apprehensive about allowing anyone other than the parents wakalatnama.
so I mean, I have tried to sort of explain to my client that the wakalatnama is a procedural requirement. It doesn't mean I'm taking instructions from the parent. I think that is the distinction I make here, regardless of what their relationship with the family is, right? That I'm going to be taking instructions from them. Of course, we take instructions from the parents also. Instructions in the sense we need to understand the family background. We need to understand where is the child going back to. All of this is relevant to the case. But if it's just about a wakalatnama and name on it, I can't tell my child, I'm talking to you, you're talking to me, let it just remain at that stage. That's the way I've navigated. I've not had a situation where I've had to take somebody else's wakalatnama, so I don't want to talk about something I don't know.
Yeah, and there's a question from Pupul, but I will say that I think Sahana has already said it very clearly that you explain documents to children. They may not be able to understand everything. So that effort of explaining what a document says has to be made come what may, if we have to ensure this principle. And then there is a question from Arya which says, given this discussion, has the JJ system in practice moved to close to punitive criminal justice system? I think we will not, we should not be commenting on this as at this point of time, because we're all feeling some things, but we're also trying to improve some things. Aditi has a question. In practice, we often see inquiries before JJB continue for 2 to 3 years because the complainant or victim does not appear despite repeated summons. And the board keeps prioritizing prosecution opportunities. But from the child's perspective, prolonged inquiry itself becomes punitive and contrary to the best interest principle. So as someone representing a CiCL, what concrete legal remedies or procedural strategies can be used to prevent indefinite adjournments and ensure timely disposal? She had another question which was about navigating a hostile environment in the board for children. So I think we'll take these as last two questions and then wind up, since we're close to 6 now. Whoever wants to go in first, Sandeep, Sahana.
Yes. Can you please repeat the first question?
So I've taken question from Aditi largely, who's saying that who's basically questioning the tough space inside the JJB and how it is hostile to children, and how do you represent a CiCL on procedural aspects. She's asking what concrete legal remedies or procedural strategies can we use to prevent indefinite adjournments which are caused from the prosecution side and ensure timely disposal, and how do you deal with the hostile environment in the board towards the CiCL? Basically, these two questions.
So with regard to timelines, the Act has specified certain timelines already. And only 2 weeks ago, we have filed a petition saying that the proceedings, the case has been continuing since several years because nobody paid attention. The problem is, especially in CiCL cases, at least in Hyderabad, police will apprehend the child once the child is released and all that is done. They never file the charge sheets. They take forever. At least in the adult cases, they file charge sheet earlier. In CiCL cases, they don't understand. So it keeps on going forever. So we had filed the petition to drop the proceedings because they were supposed to be concluded. within the time frame, it is reserved for orders. So I'm waiting for that. So the suggestion I would give is that we have to start initiating such petitions, which are there, the provisions are there in the act, and for timely disposal of the proceedings against the child. They can't keep them in abeyance for several years or even several months. That is with regard to the timelines. Now, with regard to the hostile environment, unfortunately, it exists here in Hyderabad, in the sense that the way we make the children stand, the infrastructure, the people who are dealing with them, the police, the overcrowdedness, all of this, I would say, is hostile. Above that, when we have a magistrate who sometimes uh, is predetermined or has an opinion, is quite opinionated with after reading the apprehension reports or the charge sheet also, that yes, this involvement is there. So we have, again, it has taken us a long time and effort to convince the magistrates that with regard to the version of the CCL, what is that case. So, but that hostility for us in practice, it definitely it remains unless it for us, I would say that unless you change the whole setup, we are just putting these whole systems run in some makeshift offices with people who are given in charges. That cannot be a long-term solution. We cannot have regular magistrates sitting here and multitasking. I think ultimately we have to improve upon the budgeting and the manpower and the infrastructure. Otherwise, it will continue like that.
Just to add, I think you can also do simple things like move an application to close evidence. We do this even for adults, right? Of course, there's a timeline, but I think the timeline for heinous offenses is prescriptive. There's a decision on that as well. So, but the thing to do is to file, applications. Let the court pass an order saying, no, we're giving another opportunity. And if you want, then we can take it and challenge it also, because otherwise this can be an endless game, right? And courts here at least have seen, I mean, I'm talking now about the adult courts, the normal courts in other cases, where I've had the situation where the victim is not coming, it's a sexual harassment case, or it's a sexual assault case. But after multiple opportunities, when the report comes from the IO to say so-and-so reason she no longer wishes to be part of this or is unable to be traced, then the court moves on. They also realize that this can be endless. So I think we can do simple things like that also. And about the hostile situation, again, I think one of the things that's really helped us as lawyers in the JJ board is the fact that we have organizations working within that observation home. And they involve everybody, whether it's the children there, the staff, the judges, in celebrating together or, having events together to sort of be this bridge between all of these different amongst all of these different stakeholders, because there are many. So something that Ashiana Foundation does and a whole host of other organizations here, they are the ones who create a culture where there's open communication, dialogue. So when there's a case going on, the magistrate is not seeing the child for the first time. There's a relationship and a bond there. And by virtue of them seeing them, if they're studying, they're working, they're doing things, they're also seeing that progress that is being calculated, not just calculated, that's the wrong word, but observed not only by the probation officer, but also by the magistrate who's sitting, seeing what is happening in the observation home, meeting the child outside of the court. So I think we can't expect lawyers alone to be able to deal with the hostility because we have limited skills, I would say. It does take a whole village to sort of create that conducive environment.
Yeah, thank you. And I do have some questions which we cannot take anymore. But Professor Asha Bajpai, for instance, has asked about how do magistrates look at best interest of the child. I think we've got enough examples now to tell us how they look at best interest. And when plead guilty becomes the norm, then we can imagine how much they understand best interest of the child. Also, another question around, there's a question from Rashmi. Rashmi says, how do you navigate situations where a child's expressed wishes appear to be at odds with what professionals consider to be in their best interests? Without undermining a child's agency, how do you navigate? Yeah, difficult question, difficult response. I'm sure some experiences that have been shared will have given you some ideas, Rashmi. We unfortunately can't now take up that question in detail. So unless you have some last thoughts to share, I'll request Anne to close the discussions, the webinar.
I think I had sort of made some points about, you know, the things that I wanted to talk about. I think we've covered all of that. Just that I think it's important that we communicate with our clients, set expectations right, so that there's no over expectation, under expectation. Explain what has happened throughout the process. I know some things are very difficult to explain, like Maruk was saying, the choice between bail and preliminary assessment being challenged. It's a complicated thing for us, but we need to simplify it and explain it in a way that our clients can understand and tell us why they want what they want. You know, sometimes they baffle me with the reasons they want. Sometimes they want preliminary assessment first because they're like, I want my case to come back. I know what happens if it goes in the adult system. It's because they've heard from others inside the home. So there is knowledge that comes just like with prisoners in the adult prisons, right? You spend enough time inside, you learn because of others' cases. You know the process a little bit. So I think taking those instructions is important. And yeah, I think we've gone through all of the things, but just, yeah, no, I think I'm through. Thank you.
Thank you. Your last word, Sandeep.
Um, so my experience so far, I felt is that this JJ system is special on paper. It's quite a ideal act on paper. In force, what the issue is, at least in my state, the ministry concerned and including from the judiciary side, I don't see any concrete efforts being made even in 2026 also in terms of the kind of infrastructure that is required, the manpower that is required. We have uh, acute shortage of JJB members. There are several boards that have a single member, that is a magistrate who is an in-charge magistrate. We don't have social workers and all that. There is no quorum of the board. There are no NGOs that are involved in this process here. And similarly, we have no probation officers. We have no clinical psychiatrists who are dealing with the children. So all of the system is is being managed by people who are still interested. We see that they are putting in 12 hours, 14 hours of work on that one day when they sit in their capacity as an in charge. But unfortunately, what happens is for the adult courts are far better. So in the sense that children have to travel such long distances for their case. There's only one JJB. So where will you travel? Your police station is located somewhere. So all these systems, I feel, is that unless the government wakes up and the higher authorities wake up and put in their efforts, it will continue to push it at threshold. And where at least I see that systems are collapsing here. Our observation home in Hyderabad is now overloaded. There are 100 plus children there in a small observation home, and that is leading to issues within the children. I've noticed that at least 5 years ago, the numbers were less. Now because it's overcrowded, they start fighting among each other. They have some issues and all that happening. You can't put so many children inside like a poultry farm. So this is one thing. And of course I feel that psychologically also, sometimes the people who are handling in observation home, in special home also, I find that case workers, it affects them psychologically also. Adults also get affected when we deal with children's cases. So to have that counseling for the adults also who are dealing, including the advocates or observation home superintendents and all, that would be really helpful. We tend to ignore that. We think that our personal issues will not affect the child. I have seen in my own case also sometimes it affects us. So that is something that we need to work out. Yeah.
Well, thank you so much, and thank you, Maruk, also for coming in, and leaving us with these very important thoughts and strategies to move forward. Listen to the child, interact, take your brief from the child, your instructions from the child, whoever may be signing the wakalatnama, and if necessary, you may even maintain confidentiality of certain information that the child shares with you, as Sahana had said. Make sure the judge, the JJB, the social worker members, and the principal magistrate, they understand the JJ Act and therefore use whatever is necessary to do that if we truly want to represent children. Thank you so much for joining us today. Anne, I will pass this on to you to close the webinar.
Thank you, Bharti. We from Enfold want to thank all the panelists, Advocate Sahana, Manjesh, and Advocate Sandeep Hari, and thank you for moderating. And thank you for sharing your experiences on the topic, and thank you for the participants for asking questions from the ground. It was a very enriching discussion. This is the first webinar in a series of four for the fellowship. We shall share. Sorry, one second. This is the first webinar in the series for the fellowship. We shall share information about the upcoming webinars. Stay tuned for more. Thank you.
You.
Thank you, everyone. Thank you. Thanks, Anne.
Thank you for the opportunity.